Independent contractor agreements, a legal perspective. When an individual is engaged to work as an independent contractor, this arrangement offers significant flexibility, but it requires a precise legal foundation to avoid the pitfall of creating an unintended employment relationship. An independent contractor agreement is a contract for services, distinct from a contract of service, utilized in employment scenarios. The fundamental difference lies in the nature of the relationship. An independent contractor is in business for themselves, providing services to a contracting company as a separate entity, whereas an employee is an integral part of a business organization, subject to its control and direction. A properly drafted independent contractor agreement clarifies the distinction from the outset, establishing a mutual understanding that the individual is operating their own business and is not entitled to the statutory protections afforded to employees under the applicable employment standards legislation. The legal test, burden on own account. Courts do not rely solely on the label placed on the relationship. They examine the substance of the engagement. The legal test, often referred to as the SAGAS or fourfold test, determines whether the worker is truly performing services as a person in business on their own account. The key factors include 1. Control, who determines when, where, and how the work is done. 2. Ownership of tools, who provides the equipment and software. 3. Chance of profit and risk of loss. Can the worker increase their earnings through the efficiency, or are they at risk of losing money? And 4. Integration. Is the worker's activity integral to your business or auxiliary to it? A strong independent contractor agreement must be structured to reflect these realities, limiting the contracting company's control over the how and emphasizing the contractor's autonomy. Scope of service and deliverables. One of the most critical sections of the independent contractor agreement is the scope of services. Unlike an employment contract, which often has a fluid job description, an independent contractor agreement should define the specific deliverables, milestones, and results expected. This section must be drafted with precision to avoid scope creep and to reinforce the results-oriented nature of the relationship. By focusing on the output rather than the process, this further distinguishes the engagement from employment. If the scope is too broad or open-ended, it begins to resemble a general retainer for personal services, which can be a hallmark of employment. Financial terms and tax obligations. The financial structure of an independent contractor agreement is fundamentally different from employment. The agreement must clearly state that the contractor is responsible for all statutory remittances, including income tax, Canada Pension Plan, and employment insurance. A contracting company does not withhold these from payments. Furthermore, the contractor should invoice the contracting company for their services, adding HST or GST if they are a registrant. The agreement should explicitly indemnify the contracting company against any future claims by the Canada Revenue Agency should they attempt to reclassify the status of the worker. This financial separation is a strong indicator of independent status. Intellectual property rights. A common misconception is that if the contracting company pays for the work, they own it. Under Canadian copyright law, the default rule for independent contractors is that the creator retains ownership of the intellectual property, not the paying client, unless there is written agreement to the contrary. This is the opposite of the rule for employees. Therefore, an independent contractor agreement must contain a robust assignment of intellectual property clause, explicitly transferring all rights, title, and interest in any work product created during the engagement to the contracting company, along with a waiver of moral rights. Without this, the contracting company may find itself with a limited license to use software or content they thought they owned. Term and termination. Termination clauses in independent contractor agreements must be handled carefully. Unlike employees, independent contractors are not entitled to common law reasonable notice unless they are found to be dependent contractors. To mitigate this risk, the agreement should include a fixed term or a specific defined notice period for termination without cause, such as 30 days. Avoiding language that mirrors employment termination, like termination for just cause, is advisable. The goal is to create a clear commercial exit strategy that allows the contracting company to end the engagement without the significant severance liabilities associated with dismissing an employee. Liability and indemnification. Finally, as an independent business, the contractor should assume the risk associated with their work. The independent contractor agreement should include an indemnification clause, where the contractor agrees to hold the contracting company harmless against any claims, damages, or losses arising from their negligence, errors, or omissions. Additionally, it is prudent to require the contractor to maintain their own commercial general liability and professional liability insurance. This not only protects the contracting company's assets, but also serves as another evidentiary piece that the contractor is a separate, insurable business entity bearing its own commercial risks. To learn more about our legal practice with respect to independent contractors, visit our website or contact our law firm to schedule a confidential consultation. Thank you.